Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Today I'm going to go over the court transcript with you from the February 3rd conference between attorneys for Blake Lively and Justin Baldoni, as well as the other parties involved in these cases. I'm going to wait for people to filter in here a little bit, so let me explain first how I got this, because it's not publicly available online yet. You can go to the courthouse and read it, I think, yourself if you live in New York, but also that sounds like kind of a hassle. So I had to buy this from the court reporter, which, it wasn't terribly expensive. However, you'll see that I watermarked the document, and I'm not actually going to post the document online until a little while after this stream. It ran me about $80, and so I feel like if enough people watch this, I'll kind of break even on that, so it doesn't really matter. But just to explain why I'm not posting it like I post all the other documents, this one wasn't like readily available the way the other ones have been. And also, just in the interest of transparency, I want people to watch the stream. So I'm going to wait a little bit before I post a link to the document. When I do, it'll be on my X page, Lethal Lauren 904, or on my YouTube channel page under posts. So let me show you where you can find that really quickly. Okay. All right. So you can find it right here when I do post it. I've been posting some other documents here, like you'll see the Dropbox links. If you know a better way to share with everybody than a Dropbox link, please let me know, because I know not everybody likes that. So let's go back to this. Okay. So, like I said, I'm just going to give it a couple minutes for people to filter in. I want to remind everyone before I get started also that this is a YouTube channel. I am not a cable news network. I'm not a professional content creator. I'm just a person. I can kind of relay my thoughts to you about these things on a human level. However, I am just a layperson. I'm not a lawyer. I don't have a team of researchers. I'm just a person, so take it easy on me. If that's not your speed, that's totally fine. I'm sure you can get this information elsewhere. And I totally respect your right to do that, but please just be respectful. I don't need people wailing on me in the comments. At this point, you're just going to the band basement. I'm not even going to try to explain to people anymore. Okay. But yeah, I'm just one person with kind of a shaky desk and an okay web camera. So I'm not I'm not professional by any means. And also, you should know, if you don't like bad words, if you're extremely sensitive to foul language, please know that I will annoy the crap out of you. Okay, so let's get into it. This is 60 pages long. There's a couple pages that we don't actually have to read over. Okay. Now, the reason I wanted to go over this is, we could wait until May for it to come out online, and this is just housekeeping stuff, so I'm going to skip that part. But I'm not a patient person, so I didn't want to do that. And then also, I feel like I try to make sure people know, and I don't have a large audience, so unfortunately it doesn't help too many people, but I try to make sure people know how to access this stuff themselves, because I wanted to know how to do it, and I didn't, so I'm still learning. And I had to learn how to, find the court reporter and contact them on the phone and go through all that. So, lots of people would think some of this stuff isn't publicly available, but like most stuff I feel like is publicly available in these court cases. I know there's a lot of cases where like one of the parties or both of the parties won't like that this stuff is publicly available. But as it turns out, assholes are not a protected class in this country. So we do get to see pretty much everything that's being said. Okay, we don't need to go through this. Hey, Bruce, what's going on? You think Bruce is a pirate offline? Bruce is a pirate online. Also, you are going to get my commentary and my ADHD brain thoughts if you're watching my channel. Just know that. Like, I'm not going to change. Probably not. Unless this someday becomes a full-time job, which is kind of a pipe dream. But we'll work on that when it comes to it. Right now, I'm just like, this is my break time from my day job. I have to go back to work after this, and I'm just going to chill out and go through it with you guys. I'm not worried about filtering myself. So Right. So they start out by talking about the schedule, and you are going to see some things we already knew in here, which is like when they asked for a protective order proposal by March 11th and that kind of thing. So here's what they were saying about the scheduling and all that. Gottlieb is, of course, the lawyer for Blake Lively and Ryan Reynolds parties. Okay. So with respect to the schedule, we think that the schedule that the parties submitted to the court, unfortunately, is no longer workable. We met and conferred in a conference in good faith, and the parties submitted a joint schedule to the court, which is the docket number 49 proposed schedule. Among other things, in our meet and confer, we discussed all the various dates required to be put into that schedule, including a date for amending complaints, and we had a discussion about extending that default date with the Wayfarer parties and ultimately recommended a date that was longer. So the reason I wanted to read this part was because this little bit next is kind of funny. Counsel for the Wayfarer parties did not tell us during this meet and confer that they were planning the next day to file an amended complaint, which they did the next day. That not only added significant amount of new materials, including a 168-page compendium of materials as Exhibit A, but it includes a new defendant that, to our knowledge, has not been served and that did not have an opportunity to participate in the 26F conference, in an action that's already been consolidated by this court. Now, remember, guys, this is not a document. This is just a transcript of what was said in court, in the court conference to the judge and what was said amongst the lawyers. So it was a little bit different. They were kind of going back and forth. Let's see. We're going to skim over some of this boring housekeeping stuff. Those adjustments have significant effects potentially on the consolidation of these cases because the New York Times may have its own views on whether the cases should be consolidated or not. There is authority, of course, for deconsolidating cases once they have been consolidated. We are not asking for that at this time, but simply saying that there is now a new additional defendant that has its own interests, that a media defendant, an institutional defendant, will have a perspective that is likely to be very different from the perspective of the other parties in the case thus far. So the court may have a reason in its exercise of discretion, once the Times is served and once the Times appears, to make different ruling with respect to consolidation. With respect to the schedule itself, we expect that the Times will have its own views on those scheduling questions that the parties meet and conferred on. And so we think that by itself warrants going through the process of serving the new defendant and then allowing the parties to meet and confer again, and providing a new report following that 26F conference to be able to provide a schedule that works for all parties recommended this court. And I know this kind of drones on a little bit. The beginning of this conference was pretty milquetoast, if you ask me, but I am going to go over the whole thing. The second half is like where most of the interesting stuff happens. But I do want to make sure that we go through the entire document. Okay. Given the Wayfarer defendants or plaintiffs in that action have added a new defendant, we had been contemplating amending our own complaint, and as we know they did, in the Lively action, and we're thinking about that on the timeline that had been laid out by the proposed schedule. Now that a new defendant has been added, and we think the schedule has to be reconfigured based on that anyway, our plan is to just go ahead and amend our complaint now. Okay. We intend to add both claims and parties to our complaint. So the parties they added, you guys, as we know now, were Jed Wallace and Street Relations Incorporated. Jed Wallace had filed a lawsuit against Blake Lively in Texas, and in that lawsuit, he pointed out that, Lively kind of made it sound like Jed Wallace was a party to the alleged harassment or sexual harassment and smear campaigning and stuff like that. And he said, that was obviously wrong and that they know that. He said that Blake Lively knows that he had nothing to do with the smear campaign, alleged smear campaign, because she didn't name him in her lawsuit. But she did name him in the complaint that then went to the New York Times and all that. So she then went in this amended complaint and added Jed Wallace and Street Relations Incorporated to the lawsuit. So, we think given the most efficient course of action, given that the matter still remain consolidated, would be for us to go ahead and amend on or before the 14th. Yep. Okay, we are cognizant that this court set a trial date, and we think that trial date can stay on the schedule. And later on in this conference, guys, we're going to hear the judge had talked a little bit about potentially moving the date up, accelerating things because of the public back and forth. But like I said, the beginning's a little milquetoast, but we're getting there, kind of. We are very eager to get discovery started in this case, but we don't think it is fair or efficient to try to set that schedule in motion without the relevant parties sitting at the table. So fundamentally, that is our position. The action of amending to add a new party sort of requires us to redo the 26F conference and come to the court with a new proposed schedule that will allow for an efficient management of these proceedings. So here's what the judge had to say to that. And hopefully you guys can read this okay. I can zoom in a little more. If not, just let me know. So the judge says, so let me ask you a couple of questions. One, obvious one is, why should I do that? Which I just loved that. And like, obviously, I can't see what happened in that room. I can only read on the page. So whenever I read something like this, I always, in my head, it's a little sassy. But that's just me. I'm sure he was very professional. You've got a complaint that you are prosecuting. You have a complaint that you are defending against. If I disagree with you, it would mean you would get on with the business of serving your initial disclosures. You get on with the business of serving your initial request for production and your interrogatories. Or is it interrogatories? I don't know how to say that word, guys. I know what it is, but... And at least the case is able to move forward. That doesn't mean that you can't serve second requests for documents or amend your initial disclosures, but at least we get going. Okay. As to the New York Times, it's not unusual for parties to be added in. I would hear from the New York Times once they have been served and make an appearance. It may result in the case management plan being changed, but at least the parties can get going. And I don't know if you guys saw yesterday, I put an update on my Twitter page and on my YouTube page. The New York Times yesterday added another lawyer to the suit, so to represent them. And then as well, Ryan Reynolds and Blake Lively added another lawyer yesterday for their representation. So Mr. Gottlieb says, I think the difference between those sort of typical situations, Your Honor, is describing, and this one is that in this situation, the 26F conference was held while the defendants knew they were filing this amended complaint the very next day and deprived us of an opportunity to even consider what effect that might have on the schedule or changes we might like to ask for with respect to the dates in the 26th conference. We would like an opportunity to be able to have that discussion, the parties, in order to have an efficient schedule to manage the matter. We would like an opportunity to be able to understand in that case what the Times intends to do if they intend to move against the complaint. There are defendants in the Wayfarer versus Lively case that have indicated that they intend to move to stay discovery in that case in line with the motions to dismiss that they expect it would be, and then the judge cuts him off. Sorry, say that again. What did you just say? Mr. Gottlieb, in the Wayfarer versus Lively case, there are parties that have indicated that their intent is to move to stay discovery. I will let those parties speak for themselves here. Are you? No. But in conjunction with motions to dismiss that are expected to be filed in that case. And we saw that Blake's publicists, they did file a motion to dismiss, which has not been ruled on yet. I'm simply suggesting that the net effect of all those actions is the actual parties against whom party discovery may proceed, may be affected by the positions that are taken, as well as the parties that we intend to add by next Friday. What I am suggesting, Your Honor, is that those parties have a right to be heard, and they may have their own views on whether party discovery should be stayed. They may have motions that they want to make as against the complaint, and we just think, while discovery can move forward right now, between now and next Friday, it just seems far more efficient to let us go ahead and amend the complaint, add those new parties, and give those new parties as defendants an opportunity to advise the court of their position as to whether they intend to move to dismiss, whether they intend to move to stay discovery or the like. So this guy talks like he writes, I guess, because sometimes he kind of trips up, and I'm not like trying to be a dick or anything like that, but as a reader, it kind of makes me like, wait a minute, wait. So I totally stumble over my words too, or like, repeat myself. That's fine. It's just hard to read it over in a transcript. Christine Smart, 400 people watching. Let's get those likes up. Yes, please, guys. If you could like this video for me, that'd be great. Rainbow Pickle. You saw Candace fire back over. Her name was said. Candace was funny, dude. Candace, I watched a little bit. I didn't have a lot of time yesterday, but she said something like, grab your fucking florals. And she's funny. All right, anyways, let's get back to this. Okay. The judge says, if I follow your suggestion, new parties will be added by next Friday. Then they will be served presumably quickly, not the 90 days. How quickly do you anticipate that they would be served? He says, as we did when we filed our initial complaint, we would ask those defendants through their counsel whether they would accept service immediately. If they decline, we would begin to attempt to serve the next day, which is exactly what we did in the action in December. And you guys remember there's been some back and forth over that Blake having or trying to have people served during the California wildfires, which affected Justin Baldoni's attorney, at least one of them. So that was kind of interesting. Thank you, Helene. Appreciate that. Sunshine says, remember there used to only be 30 of us in a live. Don't worry. We'll get back there. All right. That's going to add what? Another 30 days onto the timetable? It may, Your Honor. I have reason to think that it won't, given that there's currently sort of one set of lawyers representing all the defendants. But we do think that the parties and claims we intend to add may have an effect on issues with respect to representation in the case. That is another one of the reasons why we think it would be most efficient to allow us to just complete that amendment by next Friday before making decisions about the timeline. So maybe a little bit more concrete with me. Oh, the judge says maybe be a little more concrete with me. So you are a party already to this. You are asking for an extension of time to submit a revised case management plan until what date? I would suggest, Your Honor, that we set that date as, sorry, I'm just trying to get my calendar in front of me. Okay. 21 days after the 14th would be March 7th. And as we know, the judge did not give them until March 7th. They had until, I think it was the 17th, but then it ended up being the 18th because of the holiday. Okay. So we'll skip over that. I will hear from your adversaries with respect to that. I'm going to want to know right now what discovery you anticipate taking, what questions and issues you anticipate arising. Before I get to that, 2 other questions for you, which relate to the amended complaint. Whether you currently have a plan to move against that on behalf of your clients or to answer. A second question has to do with the answers. Your client has made affirmative claims in the complaint against Wayfarer Studios, some of which your client has alleged. Maybe much of it would also take the form of counterclaims to the claims of Wayfarer Studios. I'm sure, Mr. Gottlieb, you have given thought, when it comes time to answer, whether to plead those as counterclaims or whether to just stand on the complaint and how the mechanics will work. Gottlieb says, we have given thought to that. To answer the first question, we do plan to move against the amended complaint. We submitted a letter on the prior complaint. We intend to submit, or if you would like us to submit a letter, but our intent is for both Ms. Lively and for Mr. Reynolds to move to dismiss that complaint. So they're going to submit a dismissal, a motion for dismissal of Justin Baldoni's amended complaint. I was looking at the schedule for this case yesterday. Hang on. And let me show you what that looks like. So this is Pacer, where I get a lot of the documents because sometimes Court Listener doesn't update until a little while later. Okay, let's not go docket report. Let's go deadlines and hearing. So it looks like that's actually due. Where was that? Oh, this is different from what I saw yesterday. I'm looking at 125. Hang on, let's find the other one real quick. You can save cases so it's easier to find them. I'm just trying to show you guys how to do all this stuff. So Lively v. Wayfair is where everything's being filed now because it's conjoined or joined, whatever. Okay. So the answer to 50, the amended complaint with the timeline, it actually looks like it's tomorrow. This date right here, redaction request deadline, was actually for this transcript. There's no sensitive information in the transcript that we're reading, so we don't have to worry about that. But I believe this is due tomorrow. If someone else in the chat has better knowledge of like this kind of administrative stuff, please let me know. But I'll keep an eye out for that. I'll be keeping an eye out for that. Well, this is what it looks like when I check the docket. Hang on. So down here, this was the most recent filing. Let me move my head, guys, because it's in the way. Go away. There we go. This is the most recent stuff. So yesterday, you see these two, the notice of appearance and the motion for Sam, the attorney, to appear pro hoc vice. Those are the attorneys that were being added to the case. Okay. So we'll go back to what we were reading now, but I just wanted to show you guys what they were just talking about. As we go along, I'll kind of stop and explain some of this stuff from what we've seen. But what we were talking about just there, the response to the motion to dismiss the complaint, I think that means, based on what we just looked at in Pacer, I think that means they have to file that response by tomorrow. Of course, I could be wrong, but. Robin Tate, thank you for the $5. I appreciate you. All right. As for the forms of the affirmative claims and which of them will be appropriate counterclaims, I'm not sure we're all the way there yet and sort of through that. It is a large complaint, an amended complaint that was just filed. It is a large complaint. I don't know if you guys remember, but Bruce and I went over that, and it took us a collective, like, 7 hours or something. The initial complaint actually took us 6 hours to get through. I went over that with Schnitzel Ninja, but yeah, it was a long complaint, so I'll give them that. And apparently they just filed that like right before this conference, and this side of Blake Lively and Ryan Reynolds were not expecting that. So I don't blame them for that, but you know. I think the answer is some of them will properly rest upon the complaint, and some of them, assuming that the amended complaint were to survive a motion to dismiss, which I think it will, some of them would be properly pled as counterclaims. So I think we'll have to see as we get there. But our plan is to move to dismiss as to both of our clients against the amended complaint. The judge said, okay, should I set a deadline right now for you to make your motion? And when would you like to make your motion? Gottlieb says we're comfortable with the standard 21 days. Okay. So yeah, that would make the deadline tomorrow. So by tomorrow, we're going to see that motion to dismiss from Blake Lively. I hope they don't put it out at fucking midnight again. But you know, if they do, I will be here. So please hit that notification bell, subscribe, and you will see me go live with that, even if it is at midnight tomorrow. So, okay. What issues do you currently contemplate with respect to discovery? You indicate that it's going to be broad. Mr. Gottlieb, again, the attorney for Blake, says, yes, I think part of that is going to depend on how various issues with respect to the moving defendants in the Wayfair action are handled. There are significant components of discovery in that action that may never come into the case, depending on how the court resolves motion to dismiss, particularly issues relating to, for example, the defamation cause of action, which brings with it an entire set of fact and legal issues that are not present in many of the other claims in the case. So I think some of the question of how discovery shakes out is going to depend on the resolution of those legal issues in the Wayfair action. Types of discovery, I think, are not going to be a secret or surprising. I mean, there will be numerous depositions that will take place of the parties, of course. There will be significant third-party discovery around the communications that were made from the underlying sexual harassment and retaliation claims, as well as the false light claims that we have alleged and the contractual claims that we have alleged. We think that the discovery will involve the typical types of discovery requests that one would expect in contractual sexual harassment retaliation claims. and will also include significant discovery relating to the manner in which the defendants use the media and use their relationships with the media, and I think we all know what that's about, in order to shape and push forward the retaliation claim that's been alleged in the complaint. That will include communications between the defendants and their agents with media entities. So basically any communication between Justin, the Wayfarer parties, Jamie Heath, Steve Sarowitz, and their representatives with like any media outlets, which is kind of hypocritical and funny because, as we know, Blake was the one who put out her complaint to the New York Times, which otherwise would not have been made public. But, you know, why let a little hypocrisy stand in the way? And guys, if you disagree and if you fall on Blake's side of all this argument, please disagree respectfully. All opinions are welcome here. I understand that my opinions, they are different than others' opinions sometimes, but I try to see them as, you know, like different but not better. I don't think my speculation is better than anyone else's, but, you know, I can disagree strongly based on, you know, what we've seen. However, if you're going to disagree with me. Don't be a cunt, okay? All right. That will include communications between the defendants and contractors. It will include discovery over financial records of individuals who may have been paid in exchange for taking certain positions in public and the manner in which they were paid. So they want to see if Justin and the Wayfarer parties, namely Steve Sarowitz, probably because they've accused him of saying some heinous things, making a really bizarre threat relating Blake and Ryan to, you know, Hamas. And also they've, you know, said that he told people he was going to spend up to $100 million to destroy Ryan and Blake's lives. So I'm sure that's who they're talking about here for the most part. Though they think, you know, it's a conspiracy. They were all in it together and there was a secret internet mob against Blake. But actually, from my point of view, Blake just did a really bad job with PR for the movie. But okay, you know, they can certainly make that argument. Like I said before, these are certainly all words. I don't know how reliable they are. Okay. Those are the kinds of discovery issues we intend to explore in this case. Have the parties discussed an appropriate protective order with respect to discovery? And we went over those protective orders pretty recently. They have not agreed on those. The judge is going to have to rule on that. And I'm expecting that to happen soon, probably. As well as the subpoena issue, the judge will also have to rule on that. These guys could not agree on anything, and I'm not surprised. So, okay. We discussed in a meet and confer a protective order. We haven't yet exchanged drafts of that protective order, but we're planning to do so shortly after the meet and confer. Okay. We do believe there will be provisions in a protective order that will be appropriate in this case, just given the nature of the allegations and the high-profile aspect of the dispute and some of the individuals who will be involved, which many people speculate would include Taylor Swift. I'm not going to lie to you guys. I don't know much about the whole Taylor Swift of it all. I don't want to speculate too much on that, and I'll tell you why. To be honest with you, until I, you know, can give an objective opinion based on, or a subjective opinion based on what comes out in court, I don't really want to get into the Taylor Swift thing because I do not want an army of rabid Taylor Swift fans, including many, if not all, of my ex-girlfriends, to come at me for saying the wrong thing about Taylor Swift. Okay? Just being honest here. I don't want that smoke. I don't want it. There's too much of it. It's too many. I don't ever want that kind of group female attention. Okay? I just don't. So I'm happy here behind my screen. Just be nice to me. Okay. It is a case involving a significant number of high-profile individuals on both sides of the V. Of the V? Is that a saying? Sides of the V? Sounds a little... never mind. As well as third parties. In particular, addressing interests and needs of third parties and third-party privacy is going to be very important in this case. So we expect to seek protections under a Rule 26 protective order that we believe will be very important, particularly in a case where there's been a significant amount of providing of materials and leaking of materials to the media in this case. Again, hilarious considering you started it. But okay. We believe there is significant precedent from the Second Circuit and the Southern District that addresses this risk, particularly in the context of third-party discovery. This is another reason, by the way, why allowing for us to go ahead and amend the complaint and get all the parties involved before we move forward with discovery makes a lot of sense here. Because these issues are going to be of considerable importance to anyone who's a party and likely will govern the interests of third parties in discovery. But in any event, to circle back to the question, yes, please do. This man circles more than I do. All right. We do intend to propose a protective order in this case. We know that already, so I'm going to skip that. Sorry, guys. The judge says, is there any reason, if I agree to your proposal to hold off on the case management plan until March 11th, why the work on the protective order can't proceed and a proposed protective order be submitted to the court, let's say by no later than March 11th? Okay. I mean, it would seem to me that with the people you already represent and with the people that your adversary already represents, we've got a number of high-profile people involved in the case. You each know of the third parties who are going to have interests that you're going to want to protect. You haven't revealed to me who's going to be named in your amended complaint, but you already got a lot of high-profile people. Missy, thank you for the $10. I can't say, but I'll catch up later. Thanks, Lauren. Well, thank you. I appreciate every single one of you who are here right now, even those of you who are going to be mean to me in the comments. Anyways, Gottlieb says, I wasn't suggesting going longer than that, Your Honor. So yes, I think March 11th would be a date that we would easily meet. The judge says one of the topics I will want to make sure is being considered by you and your adversary is the sharing of discovery with the parties in Jones versus Abel. From my glance at the captions, it appears the main party who is in Jones versus Abel, but not otherwise in this litigation, is Jones and Jonesworks. Given their relationship to the parties, one would think that expanding the protective order to them wouldn't be much of an issue, but I will hear from them. And we do have representatives for them that will speak in this transcript as well. Okay. Gottlieb says, we obviously can't speak for Ms. Jones on that, Your Honor, but so far as we are concerned, we're happy to work with both defendants and all parties to all of these actions in fashioning a protective order, if that's more efficient. Okay, the judge says, anything else I should hear from you other than those issues that you raised with respect to pretrial publicity? So we're going to get into his issues, what Gottlieb, the lawyer, actually said regarding the pretrial publicity and the complaints he made about Brian Friedman. We'll get into that later in this transcript. Like I said, the first part of this document isn't really relating to that, but we'll get to it. Okay. Okay, the judge says, I will hear from anybody else who wants to be heard from in Lively versus Wayfair. And then on the defendant's side, on the plaintiff's side, okay, he's just asking who wants to speak. Mr. Friedman says, thank you, Your Honor, Brian Friedman. First and foremost, we would like to move the case along as quickly as possible and think that the order that we had agreed to works notwithstanding the amendment of the complaint. The reason why is adding the New York Times into this action seemed to just make it simpler to have everyone in one place, and for judicial ease, that having everyone together seemed to be a more efficient way to deal with case management. The court says, what is the status of the California case? So just to kind of speed this part along, they had initially tried to sue the New York Times in California. The New York Times, I believe, hadn't even been served, but they decided to add them to this case instead, pretty much, and they were going to dismiss the California complaint if they haven't already. Yep, here it is. Plan is to dismiss that case without prejudice today. So, okay. The court says, what have you added the amended complaint that was not in the original complaint, besides adding the New York Times and the defamation claim against the New York Times? Mr. Friedman says, the only thing from a cause of action or claim point of view that's been added were against the New York Times for promissory fraud and breach of implied fact contract against the New York Times. And that's based on information we recently received regarding the metadata of when the New York Times was involved. Those are the only new claims that have been added. and they only relate to the New York Times. Okay. So we think we could proceed forward and move forward and do it an efficient process. There's no reason to wait at all. I don't know, frankly, who the additional parties are that are going to be added by counsel that just suggested that. So he's saying he doesn't know who Gottlieb, the lawyer for Blake Lively and Ryan Reynolds, he doesn't know who they're saying they're going to add. And as we know, they did add Jed Wallace and Street Relations Incorporated, which we talked about a little bit before. So I don't know whether they would need separate counsel or they would be represented by us with appropriate conflict waivers or otherwise. I could answer that if I knew that and contacted them and would be able to respond to that, and we would move that along quickly. But I don't think that changes at all the core discovery and the core information that's needed to obtain, which I believe that everybody is kind of aware of what's needed in the case and what types of discovery will exist. And then as I also, I posted this document earlier, it was either earlier this week or late last week. Jed Wallace has been served and is now officially, a defendant in this lawsuit. So. Okay, we're skipping over the California stuff because it's irrelevant. Okay. I think this is Friedman again. I think the nature of discovery is quite clear. I mean, there's documents that we need that we are not privy to. There are documents that we exchange between Ms. Jones and her company, Leslie Sloan and Vision PR, and the Lively and Reynolds parties. There are documents that are going to be needed. There are depositions that are going to be needed in that respect. Okay. As a matter of fact, we made a request to take Ms. Lively's deposition as soon as possible. And we all know how that went. She does not want Brian Friedman to be the one to take her deposition. However, Princess, you do not get to choose. We don't need necessarily documents for that deposition, at a date that's sufficient for her. We would like to be able to take her deposition in the case. We don't think we need any documents for that deposition. For other depositions, it's going to be important to understand some of the other documents that we don't have and that are in the possession of the other parties that we are unaware of. But for case efficiency's sake, and for moving this along, we would really urge the court to allow discovery to take place and move forward, in part because the harms are actually being suffered and have been suffered since the New York Times article came out. So, they want to move on with discovery in this deposition because they're saying, Justin and the Wayfarer parties are suffering because of what happened in the New York Times. So they just want to speed that along, it sounds like. All right. Lisa Godman, I love foul language. You came to the right place. Hey, P. Mahone, what's up? God damn it. Sorry, sometimes I start humming, guys. I get it from my dad. I'm working on it. All right. There's been a number of projects to the hundreds of millions of dollars lost by Wayfarer. There have been significant damages from Tag PR and Melissa Nathan losing clients. As the court knows, when things hit the press, and especially hit the New York Times, people sometimes react before there is a judicial determination as to who's right or who's wrong. So basically he's saying shit hit the fan regardless of whether or not there was a judgment, because people, eat up what they read in the New York Times. And this is still the attorney for Justin here. These parties are suffering greatly. So it's so important from our client's perspective of having future business, of having a future livelihood, that they have a right to move forward as quickly as possible. We don't think there's any prejudice whatsoever in not moving forward. We don't think there's any prejudice to the other side in starting that discovery now and moving that along. Again, if counsel is willing to represent who the new parties were and the new claims were, I can work as early as today and find out whether that party could be represented by us legally and ethically with a conflict waiver. Or alternatively, whether we needed to get separate counsel. But if it's a party that needs to get separate counsel, obviously they're going to take whatever time they need to get separate counsel. I'm just concerned that that process in and of itself could delay the proceeding. The judge said, one reason for at least extending the initial deadlines does have to do with efficiency. You're going to get document requests, no doubt, from the other side. And you're going to get document requests from the New York Times. the New York Times is not going to be prejudiced by whatever it is that the Lively parties have asked for. They are going to have the right to demand documents even if Lively hasn't demanded those documents. If I agreed with what you had suggested, then you may have to do the same document review twice. The same thing goes for the other side. For every party that is involved, even if it's just documents, there's some inefficiency to doing a document review twice. That is not to say depositions. Depositions are not going to go forward until we know who the parties are in the case, because I am not going to have depositions done twice unless there's some very good reason for that. So, the other parties that were mentioned in this conference, they now are named in the complaints, the amended complaints. So we know who that is. I still don't know when depositions will happen. Obviously, there's a deposition deadline, but that's, over 6 months from now. So well over 6 months from now, I think. Mr. Friedman says, we're happy to work 24 hours a day, 7 days a week to make sure those documents are produced timely and right away. We're not delaying this in any way. So even though it might require more effort on our side, we are more than willing to do that. Okay. The judge says, do you want to address your views with respect to an appropriate protective order and timeline for an appropriate protective order? There's going to need to be something like that in place before documents start to be exchanged. Now, like I said, the judge still has to rule on this protective order issue. We did go over the letters sent to the court pertaining to the protective orders where they're arguing back and forth. That was where Blake Lively mentioned Perez and Candace Owens. So the judge hasn't ruled on that yet. So I guess these discovery documents, they're not going to be exchanged until after the judge rules on that. All right. Mr. Friedman says, we received a draft protective order. We could review that today. And we know they obviously didn't agree on that, so we'll skip that. Okay. This is Sigrid McCauley speaking now. She's the attorney for Leslie Sloan and Vision PR. She says, we received the amended complaint on Friday night. We submitted a letter to Your Honor on Thursday, not knowing that they were going to amend the complaint. We still intend to move to dismiss that complaint, so we are happy. The court stops her and says, what are you going to move against, and what are you... Okay, she says, there are 3 claims against my clients, Leslie Sloan and Vision PR. 2 of those are not actionable under New York law, which we contend would apply, but even under California law are not valid. The judge says, which ones are those? McCauley, the lawyer, says that's the false light invasion of privacy claim, the civil extortion claim, and the defamation claim. Okay. She says there are significant deficits in even the amended complaint after having a shot to clean that up that have not been cleaned up. Oh, that's nice. Salem's mom gifted 5 memberships. Thank you very much, Salem's mom. I appreciate it. I don't know Salem, but please tell Salem, if I don't know if it's a he or she, that I said hello. Thank you very much. I appreciate you. All right. Okay, where did we leave off here? Oh, no, this was an interesting little statement here. Hang on. So at this point, we are in a position where we want to, be moving to dismiss quite quickly because we don't believe they should have been dragged into this case to begin with. Remember, this is the PR team, Leslie Sloan and PR. Their lawyer is saying, we should never have been dragged into this. She says this was really a case about their crisis PR management company making statements about burying people and destroying people. So she's claiming, basically Justin's PR and Jed Wallace and Street Relations Inc. were making statements about burying people and destroying people. My client and her company simply have been dragged in as a finger-pointing mechanism. We want to make sure we get them out as quickly as possible. So we would like the opportunity to move to dismiss based on those legal deficiencies in the amended complaint. So basically, to the other side, they're kind of saying, I'm just here so I don't get fined, and fuck you, is what I gather. But, yeah. How soon do you plan to move to dismiss? And we know now they've already moved to dismiss. So we'll skip over this. Again, I contend that my client and her company never should have been dragged into this. So them being subject to the full-scale discovery that is going to be in this case seems inherently unfair. So the lawyer's trying to get them out of having to deal with discovery at all. But of course, I wanted to allow the court the opportunity to submit the motion to dismiss. Well, how kind of you. As you know, the standard under New York law contemplates the court having an opportunity to look at that motion to dismiss before making that determination on a stay. So we would like to lay out that information for the court, but that is one of the things we contemplate because we believe it would be inherently unfair for our client and her, her female-run company to have to be dragged in through this significant and very expensive discovery in this case when we don't contend they have any viable legal claims against her. What the fuck does a female-run company have to do with it? I mean, if they did what they're accused of, which we don't know because they haven't gone through court, nothing's been decided. Obviously, this is early stages of this lawsuit. What the hell does having a female-run company have to do with it? You can do just as much damage to someone's reputation if you work for a female-run company. So I hate when people try to leverage identities or demographics like that. I'm just like, you're hoping to get that little bit of sympathy. And I don't think that has any place in courts. Honestly, I don't. But that's just me. I'm just a layperson. This is the court of random opinion. I'm not a lawyer. But to me, I think that's kind of icky. It's icky. I don't have a better word for it. Well, I do, but YouTube wouldn't be very happy with me if I used it. Okay. Oh, and Salem's mom, thank you for becoming a member yourself. I appreciate that. Okay. The judge says, what significant prejudice would you suffer by having to serve initial disclosures and requests for production and interrogatories? These seem to be fairly standard. There may be some legal expense, but that's always going to be the case. And as we know, when they submitted their motion to dismiss, they also asked for attorney's fees and costs. So even if they're right about this and there's no reason for them to actually be involved in this lawsuit and they just got dragged into it, they've asked for attorney's fees and costs. So, those expenses could then be covered if they are awarded the attorney's fees. Okay. The lawyer Macaulay says, sure, that's fair. I just think the difference is really on the receiving end, of course, because there is always a difference. Certainly as a third party, she, Leslie Sloan, may be subject to some discovery in this case, and we will certainly cooperate in that regard to the fullest extent. However, as the court well knows, there is a vast difference between being a party. She has to be present here today and have counsel here today, and for all of the hearings upcoming. When we contend that when the court sees our motion to dismiss, we believe that you will very readily, after reviewing that amended complaint, realize the significant deficits in how it's pled, and we will hopefully be able to get her dismissed as a defendant in the case. And as we know, guys, the judge has not yet ruled on that motion to dismiss either. So we got another motion to dismiss coming, and the first one that has not been decided on yet. Whoops. Sorry about that, guys. I just moved a tab by accident. Put that back. Okay. It's anyone else on the defendant's side in the Wayfair matter. So now we have the attorney for Jones. Okay. Sorry about that. Good morning, Your Honor. We agree that there are efficiencies here in terms of discovery proceeding together in the cases. We were not a part of the meet and confer that the Lively and Baldoni's parties had last week, so we had begun to meet and confer on dates, but haven't agreed to dates on our end. So the idea of there being a collective discussion among all the related parties as suggested by the Lively parties makes sense to us as well. Oh my God, they agreed on something. That's fantastic. All right. Let's skim over some of this. Hang on. Read that. The judge asked, do you see any challenges on behalf of your clients? This is the attorney for Jones, right? Still? Yeah. Okay. Yeah, Jones. Okay. Do you see any challenges on behalf of your clients being able to work with that case management plan? The attorney says, largely, Your Honor, through the pretrial discovery, the dates are pretty workable. There are a few dates that would suggest modifications of simply because of the dates that are motion to dismiss, assuming that they will move to dismiss our opposition will be due, that we would want to move back a little bit. Okay, so for example, the initial request for productions shall be served by March 5th. As we read the calendar, our opposition to a motion to dismiss from then will be due on March 4th. So we would ask that be pushed back until March 10th, just so those 2 dates wouldn't align. And then for initial disclosures on this schedule, it was February 13th. We would ask that it be pushed back to February 18th, just to give us a little more time as well. But the place where we significantly diverge is when we get into pretrial and trial, because although there are some issues of similar factual with respect to parties, or with respect to individuals and companies, the issues in that case, both factual and legal, are very different than those involving the Baldoni and the Lively parties. So we would suggest that our trial and pretrial should come after the Baldoni and Lively parties. Okay. The judge says, I should say in response to that last comment that no motion has been made for me to consolidate Jones versus Abel for trial purposes, and I have not sua sponte come to a conclusion that they should be consolidated for trial purposes. In fact, from my first glance, what I had anticipated is that the Jones v. Abel trial, if there is a trial, would take place after Lively v. Wayfair and Wayfair v. Lively. But if there is a motion, I would consider that obviously with an open mind. Okay. And now Brian Friedman speaking on behalf of Jennifer Abel. And then he says, on behalf of Jennifer Abel, which is also a woman-owned company, like as if it matters that, oh my God. That's actually really funny. I love little tiny things like that. It's like almost passive aggressive, but not quite. Or maybe it is, you tell me. Along with Melissa's Nathan's tag company, the Agency Group. I do want to stress something that you might not know, Your Honor, which is that Ms. Jones and Jones Works filed in the Supreme Court in New York. They had that case, which has been now removed. They immediately conducted discovery in that case. As a matter of fact, they served subpoenas in that case, and even though we removed the case, apparently there were significant responses to those subpoenas, which I don't know whether we've seen them or not. I know that something came over the email this morning, but I haven't looked at it closely. Counsel may be aware of what that is and what that isn't. But the Jones parties and Jones Works were very eager to move quickly and start discovery, and in fact got responses to the discovery. Hold on, let me look at this real quick. So this was the Jones v. Abel case. Where is it? Jones. Okay. Oh, we do have documents there that I haven't read. Well, one's yesterday. Should we open that? I don't know if it's anything significant. What is this about? Hang on. We're just going to skim this real quick, guys. Because it might be like a nothing burger. Second, to the extent Jones Works parties proposed protective order deviates from this court. Okay, so this is talking more about protective orders. So I'll post these after my stream because I can't do it right now. But yeah, this is just about protective orders. So we'll deal with that later. I'm going to download it and save it. Anyways, let's go back to the transcript here. Diana T says, Team Baldoni has 2 woman-owned companies on their side. They won. Yeah, if that's the metric by which we're judging like success or viability, then yeah, sure. I don't know why that attorney decided to bring in the female-owned company thing. They know their adversaries also have a female-run company. Like, that was incredibly fucking stupid, if you ask me, but whatever. What do I know? I'm just a woman who finds that extremely annoying. All right. Kai, thank you for the 279. Love that you're reading this, Lauren, and I love that you are watching this, Kai. Thank you very much. All right. So to come into this court, and this is a Friedman speaking on behalf of Abel still. So to come into this court and say we should wait and we should not do discovery, go to the back of the bus. and there's no reason for us to be involved, and this is a different case, feels disingenuous and feels inappropriate in light of the fact that they have initiated discovery, already moved forward with it. So he's saying, like, why are you saying that this has nothing to do with you and you shouldn't be involved when you, in fact, have already started moving ahead on things? And remember that they did, since this, conference happened, they did file a motion to dismiss. So we are ready to respond and ready to move forward with the discovery. The problem is, truly, I say this with all sincerity, my clients are devastated financially and emotionally and need the case to move forward as quickly as it can within the justice that your honor sees. But it's just a fact that you should know that the Jones parties and the Jones works have already issued multiple subpoenas and have already received documents in connection with that. So obviously they felt that important to do. And why would you do that if you think that you shouldn't be involved? And we feel it important to do that too and move the case along and not wait. So I just wanted to raise that issue with you, Your Honor. The court says, Mr. Gottlieb, I will give you a chance to be heard since your adversary, just by the way things have lined up, had 2 shots. Okay, Gottlieb, the attorney for Blake and Ryan, says, thank you, Your Honor, just a few points. One is the discussion that you had with my friend about what's changed in the amended complaint. One of the complications with the amended complaint is that they have appended this 168-page exhibit that is a lengthy factual narrative that contains, as best as we can tell, sort of a day-by-day recitation of their view of what happened. That actually, and then he says, are you going to move to strike that? Mr. Gottlieb says, that is what I'm getting to, Your Honor. We haven't yet decided, but we may need to move to strike document 50-1 in large part, and that's the timeline, the evidence timeline. In large part because there's no mechanism, we think, for us to admit or deny the allegations in it. They are raising defamation claims where their pleading burden on an actual malice standard requires a significant amount of specificity in terms of the allegations that they're making. So we anticipate moving to strike docket 50-1, that timeline of evidence, which in their amended complaint, they did in fact move to strike that. So we've already seen them try to strike that. The judge has not ruled on that yet. The court says, let me interrupt you for a second and just ask your adversary. I mean, the way the federal rules works is that as the plaintiff, you can attach an instrument to a complaint. For example, you can attach a contract if you're suing on the contract. But the law in the circuit is pretty clear that you can't just attach a factual narrative for the reasons that Mr. Gottlieb has identified, which is that there's no mechanism for responding to the factual narrative that's attached. Huh, interesting. Frankly, it's not even clear that Rule 11 applies to the attachment as opposed to the body of the pleadings itself. So what is the purpose of that attachment? Now, Brian Friedman, the attorney, obviously for Justin Baldoni, Your Honor, the purpose of the attachment was to make sure that, frankly, it was almost to make sure that all of the text messages and all of the information was provided that formed the basis for the underlying claims. That was the purpose of putting that forth. So there would actually be the documents that we had. It is going to make discovery much easier because we're putting it all out there and have nothing to hide at all. The judge says, well, I mean, that is actually almost exactly what the federal rules are designed to prevent, as I understand them. You can quote an email or a text message in the body of a complaint, but you can't then just attach the stuff that the moving party, the defendant on a motion to dismiss, can then refer to the documents to the extent they're integral. But you can't just give me a complaint and then give me a whole bunch of documents. Friedman says it's not a whole bunch of documents. It is actually a timeline that is incorporated in the complaint as an attachment. Whether it was put in the body of the attachment, where some of it already is, or whether it was separated as an attachment and then incorporated by reference, we are happy if Your Honor wishes to include it in the body, but it feels like it serves the same purpose. The judge says, well, I mean, that would be a second amended complaint, and I'm not going to express a view with respect to that. I'm just asking my questions. All right. Now, Blake's attorney says, I don't believe what Mr. Friedman has just described is accurate. So basically, liar. All right. If you just take one example as I'm standing here, Your Honor, pages 80 to 81 of this document contain some images, but then contain lengthy paragraph explanations that are in someone's voice, whose voice I don't know, because it doesn't say in this document. So there's no way for us to even articulate how to respond to the speaker what the factual allegations are. I do think the rules require these kinds of allegations or messages to be put in the paragraph allegations of the complaint for the precise reason that we have an opportunity to admit them or to deny them or to make a Rule 11 motion based on them. We do intend to file that motion to strike. We're happy to make that motion orally now, but we're also happy to submit a letter motion to the court as quickly as we can when this hearing is done. I think one thing Mr. Friedman didn't mention is that he uploaded this complaint and this attachment to a website that he created. I think that the reason that it was created was for the purpose of this case. One of the things we plan to take discovery on is who created that website, who funded it, who was involved in devising it. And guys, remember, the only things on that website, let's see. Okay. Lawsuit info, amended complaint, and timeline of relevant events. So the only thing on there is public court filings. So it's nothing insane. All right. I just wanted to double check that before I ran my mouth. So, okay. One of the reasons we've raised Rule 3.6 objections is because there are significant amounts of material, including just firsthand attorney narrative as it appears throughout this document, that are being portrayed as, just recitation of facts that are going out there into the world. So we will still make that motion promptly on the docket. I just want to respond to the suggestion that we're trying to delay the discovery. We are very eager to have discovery start, both third-party and party discovery in this case. What we do not want to have happen is to have things done twice. Okay. In the meet and confer that we had with the parties, Mr. Friedman, this is a funny one, Mr. Friedman just sort of announced in the middle of it that he intended to take Ms. Lively's deposition immediately, tomorrow, from now until eternity. Some claims like that. Oh boy. I think we're being a little dramatic here, but sure. The judge says, I don't think that's going to happen, but I also don't think that you're going to be the one to choose who takes Ms. Lively's deposition. Do you disagree with that? Mr. Gottlieb then says, oh, Your Honor, I think that discussions about that are entirely premature because we don't have a notice for the deposition yet. Well, then what are you fucking whining about? So we haven't even had an opportunity to make an objection that we may or may not have. The point being, the judge interrupts him, says, you've got my preliminary views, both on whether Ms. Lively's deposition is going to be taken before there's some documents exchanged and with respect to whether Ms. Lively gets to choose her interrogator. He says, I understand that, Your Honor. That was not the point that we were trying to make in that meet and confer. Are you sure? But in any event, look, we would love for Mr. Friedman to take Ms. Lively's deposition blind without documents. That would be great for us. The problem is there are other parties who are going to want to participate in that deposition, and she is not going to sit for a deposition more than once, just like his clients aren't going to sit for a deposition more than once. The judge says, I guess I should say that if the parties all agree that a deposition can be taken without documents, I am not going to stand in the way. So like all of the parties would have to agree to that. My point is, we don't want a deposition to be taken more than once. So with respect to the ongoing harm that Mr. Friedman mentioned with respect to his clients, that is the same issue that we have with respect to our clients. Our clients have been subject since August to, Ms. Lively in particular since August, has been subject to an ongoing campaign of retaliation for reporting sexual harassment. It has been devastating to her, as laid out in our complaint. It continues to this day being weaponized by the defendants and their agents. Okay, so I do want to comment on that a little bit. They're saying there's an ongoing campaign of retaliation. What actually seems to be happening to me is that a lot of people on social media are kind of forming the opinion that Blake is full of shit here. And that's not a retaliation campaign. That's just the public opinion. So as a layperson, and as we can only make judgments based on what we've seen so far, that's not a retaliation campaign. That's literally just people having freedom of speech to air their opinions out, no matter how good or how incredibly fucking stupid they may be. So like I said earlier, assholes are not a protected class in this country. So public figures, they're not immune to this kind of criticism. It's not retaliation. It's you fucked up. And now people are mad about it. So, I mean, nobody likes to think that somebody would falsely accuse someone of sexual harassment or some sort of weird smear campaign, okay? But even more so, if you lie to people and get them to feel outraged on your behalf, and then it turns out, oh, that's not what happened, how do you think that's going to go? I mean, we're kind of seeing how that's going, right? But that's just my opinion, guys. Let me know what you think in the comments. Yeah? Okay. It has been devastating to her, as laid out in our complaint. It continues this day being weaponized by the defendants and their agents. That harm has made our clients very eager to move forward with a discovery in this case and to have her day in court. All we're trying to do is put an orderly, efficient process around that so it can take place in a way that meets the court's schedule and has the appropriate respect for third parties. Okay. The judge says, first of all, I'm going to rule the protective order proposal needs to be submitted March 11th. We've already seen that, so we're going to skip over that stuff. Okay. Mr. Friedman says, also, Your Honor, when you have one moment, I just want to be heard as to what was just stated, if possible. If it's brief, he says it's very brief. I just wanted to say that with respect to the website, like we just saw, guys, only publicly available documents that can be downloaded by anyone exist on that website. The judge says, all right, I'm going to hear from Mr. Gottlieb regarding pretrial publicity in a moment. Okay. Initial disclosures will be due February 18th, not February 13th. Initial request for production of documents will be March 14th. Interrogatories will be due March 14th. Okay. I'm going to adopt the rest of the case management plan as originally submitted, so we'll skip over that case management stuff. With respect to Jones v. Abel, I'm going to adopt as the case management plan and scheduling order in Lively v. Wayfair. Okay. Finally, with respect to the post-discovery status conference, okay, says, so post-discovery, they're having a status conference on October 21st. So that is almost 8 months from now. Yeah. The parties had previously indicated the deadlines on which they plan to file their motions to dismiss. Those are the deadlines that are set forth. Okay. Now we're going to skip over the rest of this scheduling stuff. Unless there's anything in the future, because we've already seen some of this stuff, like the amended complaints and the motion to dismiss. Okay. Okay, Mr. Gottlieb, you wish to be heard with respect to pretrial publicity. Mr. Gottlieb says, in this court's January 27th order, it asks that the parties be prepared to address the letter motion about pretrial publicity. The basis for our motion is encompassed in the letter. The issue, in our view, is relatively straightforward. It is that the conduct that Mr. Friedman has been engaged in since December has been in direct violation of New York rules of professional conduct, which applies to statements made by lawyers who are participating in litigation of a matter and prohibits extrajudicial statements that a lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. We believe we have laid out in our letters why the statements Mr. Friedman made violate that provision. We believe we've also laid out in our letters why the statements do not fall within the exception provided at Rule 3.6d, which does provide for responses that a lawyer can make that shall be limited to such information as is necessary to mitigate recent adverse publicity. Mr. Friedman has acted in direct contravention of Rule 3.6 to date by making inflammatory extrajudicial comments regarding Ms. Lively and her character, as well as her motives for entering into this litigation and conduct within the litigation. He has made that to the media across the country in different sectors. We have provided a list of his public statements at docket number 17-2. Okay, and we've seen that. The statements also include not just sort of press releases that Mr. Friedman has sent out to the media, but appearances that Mr. Friedman has made, shows, including shows hosted by his former client, Megyn Kelly. And I know that was the transcript writer, not unless he actually said host, which is pretty hilarious. Megyn Kelly, and threats to establish a website, which has since been established that he claimed would quash Ms. Lively's claims. The website is now a reality. While we agree that the only things we've seen posted to date are the pleadings, one of those two pleadings, the exhibit, we believe was intended to convey information that they weren't willing to put into the verified complaint that they have filed with this court, but instead attached as an exhibit as a lengthy factual narrative. Wow. We put Mr. Friedman on notice of his ethical obligations no later than December 23rd, when we sent him the letter reminding him of his ethical obligations in connection with the initial statement that he provided to New York Times. And in that letter, we also notified him that he was liable for claims of defamation that our client had, and as well was a material fact witness in this case as a result of these statements that he has made and conduct in which he was engaged back in August, all of which is laid out at docket number 17-3. Really, the only response that Wayfair counsel has offered is that their efforts are not prejudicial, and that essentially we started it with the New York Times article that they've cited. But those arguments should be rejected out of hand. We briefed this and addressed this in our papers, but Rule 3.6 is a specific rule that governs extrajudicial statements by counsel, by lawyers. It is a rule directed at lawyers. They have not made any allegation that there were any extrajudicial statements by lawyers in the New York Times article, for starters. But in any event, they don't dispute that they have been out regularly in the press making attorney statements addressing the factual allegations in this case, attacking the character of Ms. Lively, using words that describe her motives, her character, describing the complaint as being filed for PR purposes only, and the like. Wanderer says, I think Colleen Hoover's a sham. Sorry, but that's what I think. I don't really know anything about her. I mean, I know she wrote the book, obviously, but... And also that she got kind of weird and purged Instagram or something. So, all right. Let's see. As we've explained in our letter motions, that assertion is both incorrect on its face, and it would gut the purpose of Rule 3.6, because it would simply allow an attorney, once somebody else has said something, to sort of speak on and on and on in any way they wanted to, rather than the limitations that are provided by Rule 3.6. Speaking of attorneys speaking on and on and on, sir. Contrary to Mr. Friedman's public statements, we have not requested a gag order in this case. What we have requested in our initial letter is that the court should exercise control over its docket to avoid improper conduct by counsel. And we cited the case Heiss v. Lemon from the Eastern District of New York. Okay, and I'm going to skip over the case law stuff, guys. Although we cited that Eastern District case, there is also a Southern District cases that stand for the same proposition. Okay. That is really all we're asking for here, is that this court adopt Rule 3.6 as a rule of conduct going forward and instruct that all of the counsel that have appeared before this court must follow Rule 3.6. Okay, and that would be enforceable via Rule 16 if not followed. So he's saying, we weren't asking for a gag order. Okay. So the judge responds saying, why isn't the harm that you identify sufficiently addressed by the combination of the following? Number one, with studious attention by the court at the request of the parties to the requirements with respect to filing, and particularly making appropriate motions to strike. And the court does have sanction power if it looks like the court's docket is being abused for the purpose not of litigating, but of improperly disseminating information that would prejudice a jury. So he's saying the court can sanction them, if they think the docket is being used as a way to communicate with the public or the media or whatever in a way that would be like influencing a potential jury for the trial. Okay. Number two, as Judge Furman noted in Munoz, appropriate voir dire of the jury when the jury is impaneled. And as Judge Furman also noted in Munoz, the handling of any ethical complaints by the appropriate body, which would be the ethical authorities in New York and whichever other ethical bodies are appropriate. Okay, Gottlieb says, so I think taking those in reverse order, the reason why just relying on ethical complaints to the bar doesn't really work is because you have attorneys from multiple different jurisdictions, including Mr. Friedman, who is the attorney we have addressed, is appearing in this court pro hoc vice. I don't know if I said that right, but basically means someone who is from a different state or jurisdiction or whatever. It's like they are requesting to represent in this jurisdiction, in this court, somebody, just for the purposes of this trial, I think. That was my understanding of it. I'm sure I butchered the explanation. So I think there's a special need in this case to clarify the rule that will govern the extrajudicial statements, given the conduct of attorneys in this case thus far going forward. It makes it different from a typical case where you have, for example, the U.S. Attorney's Office and the Federal Defender's Office that are regularly appearing before this court, and it is obvious what bar organizations will be able to resolve those kinds of complaints. We think that filing motions to strike and sanctions power are, of course, remedies that are available, but they are remedies that can't unring the bell once you have statements that sort of ricochet out through the media, both through traditional and social media. We are in the process in this case of trying to trace how far some of these statements have reached, but they are into the thousands upon thousands when they're repeated on TikTok and other social media platforms. It's very difficult to unring that bell when the attorney is specifically targeting the sort of way that the public is consuming information about a particular case and doing it in a way that is directly attacking the character, integrity, truthfulness of a witness without being subjected to the kind of tests that are provided in the adversarial system, which is through cross-examination and the rules that govern the federal rules of civil procedure. Okay, so I'm going to skip that. Hang on, this is just more about voir dire. So he's saying those rules are clearly not sufficient, so that's why they have Rule 3.6 in New York. And that's why it imposes the limitations that it does. Okay. The judge says, give me an example of one statement that you're particularly concerned about, one or two statements, and he's going to give like 7. So, okay, Blake's attorney says, sure. So we've laid out these statements. And I'm just going to read the statements, guys. The first statement he cites here is, we are releasing all of the evidence which will show, and these are Friedman's statements. We are releasing all of the evidence which will show a pattern of bullying and threats to take over the movie. None of this will come as a surprise because, consistent with her past behavior, Blake Lively used other people to communicate those threats and bullied her way to get whatever she wanted. We have all the receipts and more. Okay. And then Blake's attorney says that's making a statement about her character, but also characterizing the evidence that he intended to release, which is a one-sided presentation of evidence. Okay. Filled with attorney testimony in it. Okay. Blake's attorney says there's a series of statements from Friedman from December 21st to 28th in which he makes false representations about the conduct of his own clients. Okay. Here's a statement he made on Megyn Kelly. He said, sorry, the dude's looking... And the transcript, when I'm reading the transcript, it's like we have to read all the stuff where they're just like, oh, wait a minute, let me shuffle the papers. Okay. He says, Blake Lively, if she was sexually harassed to such a degree in this film and in this situation, she wouldn't have returned to the film. It's very clear what's being planted. There's evidence for all those points. There are text messages for all these points. He continues in a statement, Blake Lively was no victim. She was in control. She was in power. She took over the film. She used the allegations of sexual harassment. She used these allegations to bully and to try and leverage her position so she could be the de facto director in this case. The judge says, isn't that in fact exactly what's stated in his complaint? Mr. Gottlieb says, no, I don't think so, Your Honor, especially the statements. There are statements from before he even had a complaint that was filed, so the answer would be no, but I think that, and then the judge says, the vouching for this is unlike any other case. I get your point on that. Okay. I think also, Your Honor, there is a mechanism by which attorneys can make statements about the allegations in the complaint without making statements about the character of the opposing parties. Those usually include words like, as alleged in the complaint, or as we have said at paragraph, whatever of the complaint. An attorney can make a statement to explain why their allegations are correct or why their allegations are false, But the point of Rule 3.6 is you're not supposed to launch attacks on the other party's character, which is exactly what's being done here. Once you have a matter that is in litigation, and once you have invoked the jurisdiction of a court to hear the dispute. Okay. He's also making representations about the state of the evidence. In each of these, he's making representations about the state of evidence that is a representation about materials that are subject to discovery, and materials that, when he makes those statements out to the media and releases material in a one-sided fashion, we don't have an opportunity to rebut it. The only way we have an opportunity to rebut it is for us to then go out and make competing statements in the media. That's precisely what Rule 3.6 is defined to avoid. The best example of that is at pages 6 through 7 of document 17-2, when Mr. Friedman took a video clip that is a video depicting one of the allegations from Ms. Lively's complaint. He released that video, the video of them doing the scene where they're dancing in the bar. Okay. He released that video publicly to a number of outlets, and then he made comments about what he believes the video proves or doesn't prove. That precise factual allegation that is at issue in Ms. Lively's complaint that they are responding to through the press by releasing the underlying evidence that's supposed to be provided in discovery, and then making comments about his opinion and his views about what the video does or does not show. The only way we can respond to that, given there's no opportunity for us to yet respond to that in court, is for us to then go out into the media and give our own views and our own take on that evidence. That is exactly the kind of arms race to the media when you have a disputed factual matter in court that's supposed to be resolved here in court. It's not supposed to be resolved out in the press, with the lawyers going on shows, arguing about a piece of evidence that is likely to go before a jury at trial, in this case, at the end of discovery. So that's particularly concerning to us. If there are no guardrails in place, it basically means that throughout the conduct of this case, we all have to do our work in this case, and then we have to go out on shows arguing against each other about what a particular document or text message or video means. We think Rule 3.6 is clearly designed to stop that type of process when you have a case being litigated in New York. Sorry, guys. 1 sec. Okay. The judge says, do you have any issue with respect to Mr. Friedman creating a website if it was just limited to the filings in this case, making available to the public for free what members of the public otherwise might have to pay a fee to the court system for? Blake's attorney says not at all. We have no problem with that. Sure. Our objection is to the exhibit to the complaint that they have attached, the exhibit being the timeline of evidence, which we will address in a motion to strike. We have no objection to Mr. Friedman creating a website and putting publicly filed pleadings or motion papers out on that. We understand that to be a not uncommon practice, and we don't have objection to that under Rule 3.6. Okay, and then he asks Justin's attorney, Mr. Friedman, to answer. First, let me say that what is conspicuously missing from the argument that you just heard is that for months before any filing was made in this case, the New York Times, giving 12 hours notice, having had months of working with counsel and others, put out an article that completely devastated, and then the judge cuts him off. Says you don't have evidence that Mr. Gottlieb was the one who was making those statements or a lawyer. Okay. I understand the argument that those are the rules. You have some latitude to respond to the New York Times article, but that only gets you so far. Mr. Friedman says, I agree, Your Honor, but the point is they have a very pointedly used the press, and the New York Times used the lawyers to make sure that they were doing was appropriate and above board. I do want, judge cuts him off again, says that's a disputed issue in the case as I understand it, to which Mr. Friedman says, I think it is a disputed issue in the case, but we know it to be a fact. The judge says, what ends up being facts are things that either the jury finds as facts or the court finds as facts. Fair, yeah. It is not a party's assertion that something happens to be a fact. That's not the way courts of law work. Mr. Friedman says, I completely respect that. This has not been a one-way street in this case at all. I can walk through statements made by Ms. Lively's attorneys that have the same force and effect. And then he's quoting here. On December 31st, Wayfair and its associates had violated federal and California state law by retaliating against her for reporting sexual harassment and workplace safety concerns. The actress/producer's attorneys said in a statement in a federal complaint Ms. Lively has brought this litigation in New York, where much of the relevant activities described in the complaint took place, but we reserve the right to pursue further action in venues and jurisdictions appropriate by law. Another one. Nothing in this lawsuit changes anything about the claims advanced by Ms. Lively. We look forward to addressing each and every one of those allegations in court. We encourage people to read Ms. Lively's complaint in its entirety. Then the next one, this is not a feud arising from creative differences or a he said, she said situation, her lawyers state. And then the judge cuts him off and says, that is exactly the point, which is that you could have said, listen, I encourage the parties to review our pleadings in this case. Look at our pleadings. You will see they tell a very different story, but you went a little bit further than that. And then Mr. Friedman says, can I just read something else they said on January 6th? And he quotes, and their response to the lawsuit was to launch more attacks against Ms. Lively since the filing. They said sexual harassment and retaliation are illegal in every workplace and every industry. A classic tactic to distract from allegations of this type of misconduct is to blame the victim by suggesting they invited the conduct, brought it on themselves, misunderstood the intentions, or even lied. Ms. Lively's team wrote, another classic tactic is to reverse the victim and offender and suggest the offender is actually the victim. It's not the thing in itself is not funny, but just the fact that we're having to have like someone kind of court-splain that is kind of funny. Okay. These concepts normalize and trivialize allegations of serious misconduct, and it goes on. Okay, the judge says, maybe you're convincing me that I should adopt as an order of the court that the lawyers are required to comply with Rule 3.6. Mr. Friedman says, I am actually in agreement with that. We want to comply with Rule 3.6. We have no objection to that. The way this showed itself today was a gag order on me not being allowed to speak to the media at all. But I do want to just raise one other issue, an issue where they said, a woman speaks up with concrete evidence of sexual harassment, retaliation, and the abuser attempts to turn the tables on the victim. This is what experts call DARVO, deny, attack, reverse, victim, and offenders. Wayfair has opted to use these resources of its billionaire co-founder to issue media statements, launch meritless lawsuits, threaten litigation, and it just goes on and on. This has not been a one-way street. There are pages of this. So he was quoting, obviously, the other attorneys. I don't mean to waste your honor's time, but I certainly would stipulate to the professional rules of conduct and certainly want to abide by that. My grave concern is that my client suffered hundreds of millions of dollars in prejudice as a result of actions they were blindsided by. The judge says, you know, both sides are saying that they suffered hundreds of millions of dollars in damages. I hear what you're saying. I also hear what they're saying. Although I was hesitant when I came on the bench to adopt Rule 3.6, since you're both agreeing to it, I'm going to adopt it. Okay, he says he's adopting it with some reluctance, because while it's my expectation that the parties will comply with their ethical obligations, I don't expect this case, and I wouldn't want this case to devolve into satellite litigation over the comments of a lawyer. Both have said a lot in the pleadings that you've got in front of the court. That gives, I think, the public plenty to feast upon. I mean, I won't argue with that. So I will adopt 3.6 as an order of the court on the consent of the parties. Mr. Friedman says one final comment, not to sound like a 4-year-old fighting a 4-year-old with that they started it. But, you know, in these kinds of cases, once someone says something, it becomes fact. There's no way to fight against it. You start to lose things immediately without the ability to have the court's adjudication. This was not started by us, Your Honor. So one of the things that the judge says, one of the things I had also contemplated was accelerating the date of the trial from the date I had previously disseminated, and which I have now set in as an order for the court. I'm not going to do that because I'm convinced that the parties need the time for discovery. But if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial, one of the tools the court does have available to it is to accelerate the date of the trial. So that's something that is out there. I don't want to do that. So he's saying it's still a possibility if things start to, or continue to be litigated in the press, the judge can move up that court date. But for now, the judge says we are sticking to the trial date that I set. So there will come a time when, unless this case is settled, a jury will speak on these issues that you both have raised. Then you will deal with the jury verdict. 3.6 will apply. Mr. Friedman says, I appreciate that. The unfortunate thing is damage is done before a jury speaks. And the judge says, that's the reason why you each have sued. I get it. All right. And that was it, guys. That was that whole transcript. Like I said, I will post this online. But not right now. I'll post it later on my YouTube page and on my Twitter page. I'm not sure if it's going to be today or tomorrow. But if you could please like this video, it would really help me out. Subscribe and hit the alerts for notifications, because like I said, that motion to dismiss by Blake Lively in response to Justin's amended complaint, it is due tomorrow. So as we know, they waited for their amended complaint until midnight, so hopefully they won't wait that long, but we'll see how it goes. And I will be here when it hits the docket. So thanks, everybody. Appreciate you. Have a good day, and I got to get back to work. See ya.